We are here in the matter of Melissa Culverston versus Turning Leaf Residential Rehabilitation Services, case number 25-01085-NI. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Network 180's motion for summary disposition. And at this time, I would invite counsel to place your appearances on the record. We can begin with the plaintiff.
Good morning, Your Honor. Reno Arable for the plaintiff.
Thank you, Mr. Arbel.
Cameron Ghetto here on behalf of Turning Leaf, Your Honor. Hi, Judge Rossi. How are you?
Good, Mr. Ghetto. Nice to see you again. And you're muted, Mr. Jolkin.
Sorry about that, Judge. Good morning. If it pleases this honorable court, Art Jalkin, appearing on behalf of Defendant Network 180.
Very good. And Mr. Jolkin, this is your motion. I did read your filings here, and I did want to clarify at least a single issue. And I didn't bring the entirety of this file home with me before the hearing. When this originally was filed, was it solely as a medical malpractice action, or has it always had the counts? I think it's always had the counts for gross negligence and negligence as well. Is that accurate?
I believe that is accurate, Judge.
Okay, and insofar that I issued that order, back in June, I think, indicating that it needed to be refiled with the proper affidavit of merit. It seems to me that would only apply to the count sounding in medical malpractice. Is that accurate as well?
No, that would not be accurate, Judge. The plaintiffs, this has been a long-standing attempt by plaintiffs bar to avoid the requirements of affidavits of merit, and also, interestingly, and more importantly to plaintiffs, is to avoid the statutory caps which are applicable to malpractice. That is, you can't file a malpractice claim, call it negligence, and not have an affidavit and not be subject to the caps. The only exception to that particular rule is if the negligence is, as they say, res ipsa loquitur, the thing speaks for itself. So if the surgeon operates on the wrong leg, that would be clearly a negligence claim, because you don't need an expert to testify about which leg was proper. But to allege negligence does not evade or avoid the necessity to file an affidavit of merit.
Okay, so your motion, therefore, is as to all claims asserted against Network 180 in this matter, in that you're saying they all, at the end of the day, are properly characterized as malpractice claims, and they all stem out of those allegations, and your arguments obviously are applicable as the deficiencies of the affidavit. So it's you've clarified for me accurately. It's to all claims, both gross negligence, and the malpractice claim.
That's absolutely correct, Judge. In fact, Your Honor's prior ruling via the order of June 15th, 2025, specifically indicated that plaintiff may file an amended complaint with an affidavit of meritorious claim pursuant to the statute 600-2912D.
Okay, all right, and I think that logically moves us to the substance of your argument today to dismiss this case, and it does, after all revolve around that requirement of the affidavit of merit. And first of all, you're saying that is not an affidavit that's been submitted at all.
Yes, Judge, and just for this, to bring this court up to date, about 20 minutes ago, plaintiff's attorney emailed over to me an affidavit signed by Gerald Shiner, an actual affidavit. And
with the notary and all those appropriate.
Exactly. Yep, he did. So, and the law is, if that were the only deficiency, then we could move forward with that affidavit, which he has not filed with the court, I do not believe. But
I'm sorry to cut you off. It was filed with the court, and Just 30 minutes ago, Your Honor, but it was just filed now, Your Honor.
Okay, so we do have an actual notarized affidavit, and you're, it sounds like agreeing, Mr. Jokinen, that that would, because that is the proverbial procedural remedy where I can go through that analysis about prejudice and apply my discretion, that would cure the defect, but you want to proceed today on your more substantive arguments that it is the wrong expert for this case.
Yes, that's correct, Your Honor.
Okay, and you know, as I reviewed the your memorandum and obviously plaintiff's response and your reply, you know, the question occurred to me. You know, I think plaintiff's argument, to summarize it probably not very articulately, is that you know, the standard of care here is an overarching standard of psychiatric supervision, and I totally understand that you don't agree with that. You're saying there is no such standard of care in effect, and that this is more akin perhaps to a scenario where we have mid-level providers, you know, providing care perhaps in a hospital setting. And in that case, of course, you know, if you're alleging a breach of a standard of care by an RN, you submit an affidavit of an RN, and if it's a radiologic technician, you submit the affidavit of a radiologic technician, et cetera, to establish what the proper standard of care in that more general setting is. Am I summarizing that fairly?
Exactly, Judge. Using your analogy, if a pediatric intensive care nurse did something wrong in the pediatric intensive care unit, the plaintiff then just retains a pediatric physician and says, this nurse did something wrong, this resident did something wrong. No, that's not how it works. You can't get an overarching expert to talk about what goes on down the chain of healthcare. And in fact, Dr. Shiner, God bless him, he's well known to the defense bar as is certainly a shining example of plaintiff's experts throughout many years. But anyhow, he states his professional time is spent in the clinical practice of psychiatry. Looking at his affidavit, which you haven't seen, but it utilizing the same words that was in the original attachment to his amended complaint, he talks about things such as properly prescribe appropriate medications, dosages. Clearly, I have two non-medical defendants who practice distinct specialties unrelated to psychiatry. The plaintiff's attorney, there's no way he could, as the statute requires, reasonably believe that this Dr. Shiner meets the requirements for an expert witness under section 2169. The qualifications, among other things, include an active clinical practice of the same health profession in which the party against whom the testimony is being offered. Dr. Shiner has never been a qualified mental health provider such as Amanda Irwin. He has never been a licensed professional counselor such as Kayla DeWord, the two individuals that are being sued here. He identifies in his CV, which I've attached, absolutely nothing to indicate any type of practice such as these two individuals have. Plaintiff cites the case of Stokes v. Swafford to support his position that, you know, maybe the law has changed somewhat. In Stokes, the defendant Swafford was a diagnostic radiologist and a doctor. The plaintiff's expert was a neuroradiologist with a subspecialty in diagnostic radiology. Michigan Supreme Court said, since this case involves the interpretation of brain scans by a doctor, plaintiff's expert will suffice. But plaintiff would have us say that a psychiatrist can testify against a psychologist, against a social worker, against a therapist, because it's overarching psychiatry. That's not the law. That has never been the law since this statute has been enacted.
Okay, yeah, no, and I was trying to flip here to the exact let's see here. Yeah, and I think that the plaintiff's counsel identifies this as the medical standard of care for suicide risk management across an interdisciplinary team. And I think what you're arguing is, Judge, that's not a standard of care at all. That's at least contemplated by either of these individuals that are Network 180 employees' job descriptions.
Absolutely not, Judge. These are, in essence, social workers.
Yeah, now it does occur to me that, of course, even social workers, and various other professionals, including, for that matter, teachers and school counselors and the like, do have mandatory reporting duties that might encompass suicide risk in some cases. How do those tie into the standard of care if they do at all?
Well, they do not at all, Judge. This, Mr. Brown was a many-year treater at Network 180, and these they have a team approach with counselors, licensed counselors there who see this patient. And when they saw him on July 5th and on July 6th, they're based upon their background, training, and experience, they did not believe that he was a suicide risk or potential harm to himself or others. So plaintiff is alleging the contrary, that, well, you fell below the standard of care when you saw Mr. Brown on July 5th and July 6th. Well, you have to have an expert to say that we fell below the standard of care. You can't have a psychiatrist say that. You need someone of the same background, training, and experience to say that.
Okay, and this is not the res ipsa loquitur case that even though Mr. Brown did make a ultimately successful suicide attempt shortly after he was seen by these individuals who, didn't, whether they, it's unclear to me whether or not how much suicide risk evaluation they made, but or what, honestly, that they could have done about it, because obviously neither of these folks could admit him to the hospital. I suppose they could have said, I want you to go, or accompanied him to the emergency room and had a, physician make that determination or not. But, is this the res ipsa loquitur type case?
Absolutely not, Judge. The Mr. Brown had a long history of suicide attempts, multiple suicide attempts before this. So the case law has suggested in malpractice cases such as this, that the professional relies upon his judgment, experience, and training to evaluate the particular patient as to whether or not he is a current suicide risk. The opinion of one of the courts, and the name of the case escapes me now, you can prevent all suicides by locking someone in a room and strapping them to a table and feeding them 3 times a day, and there will be no more suicides. But we cannot live in a society like that. Professionals are allowed to exercise their discretion to allow individuals such as Mr. Brown to live as normal a life as they possibly can. And in fact, he was a suicide risk for decades. But unfortunately, as does happen often, sometimes, people do commit suicide despite the best of care. And to evaluate that care, you need someone of a similar background, training, and experience. In my responsive motion, I've attached affidavits of my 2 experts, Kimberly Smith and my other individual, who specifically talk about their familiarity with the standard of care. Shiner cannot talk about his knowledge of the standard of care for these folks, my clients, because he's never practiced that.
All right. Well, I think I understand the content of the motion. Let me turn to And my understanding, Mr. Ketto, is that you concur in the motion because there's not a medical malpractice claim against your client. You don't particularly have a dog in the fight at this procedural point.
Well, we actually, we do. I mean, we concurred in the motion because we think it should be granted. I mean, MCL 600.2169 is it's a statute. It's not optional. It's not a suggestion. It requires expert matching. And in this case, if plaintiff wishes to proceed against Network 180 in the same lawsuit as they've sued Turning Leaf, plaintiff has to match the expert. There's an important policy reason that's been around for, I think, 30 years now, maybe almost 40 years. We don't want family practitioners coming into court and commenting on whether a gallbladder surgery was done correctly. We don't want radiologists coming into court and commenting on whether a baby was delivered correctly. Here, I actually, when I got in the office this morning, Your Honor, I reread Stokes, to try to find out what on earth it was the plaintiff was talking about in the response brief. Stokes stands for one proposition and one proposition only. It stands for the proposition that there is an important distinction to be drawn between specialties and subspecialties when it comes to physicians. It didn't change anything at all about the requirement to match experts in medical malpractice cases. And frankly, for the life of me, I do a lot of malpractice work. I think I probably had some malpractice cases before, Your Honor. I can't for the life of me figure out why a plaintiff would want to fight on this issue, because even if the plaintiff somehow convinces Your Honor that this is appropriate, they're building a mile-wide appeal issue into the middle of this case, because this is well-settled law. It's been well-settled law for a significant period of time, and to the extent that Stokes came out last year and is a Supreme Court case, it didn't change anything relevant to the issue that's before this court. Now, there's a second part of the statute that Mr. Jalkin and I think referred to that is very important, and that is that the practitioner they have to, and I put this in all of my affidavits to make sure that I comply with the statutory requirement, they have to affirm that they spent a year clinically practicing in the same specialty as the person who's being sued. And Dr. Shiner affirmed in his affidavit that he doesn't. He practices as a psychiatrist, which is a completely different specialty. He didn't go to school to be a therapist. He didn't take the test to be the therapist. He's not licensed as a therapist. I mean, if we want to go into a hypothetical, Your Honor, let's say Dr. Shiner was both a psychiatrist and a QP, MH. Okay, let's say he had both. Okay, he would have to put into his affidavit that he spent a year as the QPMH, the year before the malpractice doing this for him to match the specialty as contemplated in Stokes and in the statute. There are just so many reasons why what plaintiff is doing here is just simply an incorrect interpretation of the law. I probably couldn't even touch upon them all, but I do want to conclude with this. This isn't a situation where somebody sat down and thought that they were getting the right expert, and then due to some kind of a judicial determination after the fact, was surprised and their client would be prejudiced. And they, this isn't a situation where somebody can go back and just go find another expert. This court already ruled, and this court told plaintiff what it was they needed, and plaintiff went and got something different. I don't understand why anybody would hire Dr. Shiner in a case like this. I've literally never in the almost 30 years I've been doing this, ever had this argument be made where a psychiatrist is brought in to testify for or against a licensed health professional with a different license. It's the first time I've seen it, and I think it's completely incorrect under the law. And I think Your Honor ought to dismiss Network 180 out of this case. Thank you.
Very good. Well, I guess the question's out there. Mr. Erbo, with no psychiatrist present that I've seen anyways for Network 180 in this case, how can I find Dr. Shiner's affidavit sufficient?
Yes, Your Honor. So the case law says it's the most relevant specialty. And what we pleaded in our amended complaint is that the defendants failed to identify suicidal risk, to escalate that risk appropriately, to ensure safe placement, supervision, and monitor for a known suicidal patient, right? That's the specialty we're looking for. Okay. And brother counsel says two things. One, he's not a suicide risk, but then also says, yeah, this person has a long history of suicidal risk and attempts. Okay. And then 2 days before his suicide, he spoke with Amanda Urin and she identified that he was a suicidal risk and that he was depressed. And the day before that, 3 days before he took his own life, spoke with Kayla DeWeed and they talked about his suicidal thoughts. So for them to say this guy has decades of suicidal attempts and risk, and then for the two counselors that we're talking about here today, Your Honor, to speak with him 2 and 3 days before his suicide attempt, for them to come and say, oh, he wasn't a suicide risk, people need to live their normal lives. It's not a normal person. This is not a normal life. This person was staying at a specialized adult foster care designed to treat people like him, people with mental illnesses, Your Honor. So what we're pleading is not just a counselor who's talking to someone who's depressed because they're going through a divorce. This is at a special facility meant to treat people with mental illnesses, right? So we can't just go and get any person who's gonna who just maybe is just a nurse or a counselor at a school who doesn't deal with this type of issues. This is a very specific issue we're dealing with, suicide risk. Okay, Dr. Shiner, I think it's very fair to me to reasonably believe that an expert with all these decades of experience tells me that he's able to sign this affidavit of merit because he deals with these type of clients all the time, suicidal clients. He's a psychiatrist who deals with suicidal clients. And what we pleaded in our amended complaint is just that. It's the specialty of suicide prevention. It has nothing to do with the title. The title is the title. It's not, I don't even think a QM, qualified health management, I apologize, Your Honor, but the abbreviation for
A mental health professional.
yeah,
No, I understand who you're talking about.
Yeah, QMHP. That's not like a license you go to school for. I think it's just a title, Your Honor. And the case law doesn't say match the titles. It's match the specialty. The specialty at issue is suicide risk and prevention. And Dr. Shiner's affidavit is very clear. He has decades of experience treating suicidal patients. So yes, he's very qualified to opine on this issue. And I think it's very fair to tell the court, Your Honor, that I reasonably believe that as well.
Well, but I mean, isn't the argument fundamentally here that it's an unfair comparison and that Dr. Shiner is a psychiatrist, if he saw this patient, would have a panoply of options that he could admit him to the hospital potentially if he had admitting privileges. He could change his medication on the spot. He could chemically incapacitate him, I suppose, doing the chemical version of what Mr. Jelkinen talked about, the straitjacket, or for that matter, I don't know if psychiatrists still do confine people and have them immobilized in straitjackets, but if anyone was going to do that, it certainly wasn't going to be a counselor, a master's in psychology or a qualified mental health professional. That was going to be a psychiatrist. Why would a person with that level of, certification be the right expert to testify against what I'm going to characterize as more mid-level treaters who do have a role in this, but don't have that whole range of options in front of them?
Well, Your Honor, is defendant's argument that a mental health agency who is responsible for providing mental health services and working with the defendant turning leaf, that's a specialized adult foster care for people who have severe mental illnesses, are those individuals does not have any responsibility to someone who is suicidal and saying I have suicidal thoughts days before he commits suicide? I mean, is their whole entire argument is that someone can just come to this facility with mental illnesses and suicide risk and tell the counselors I have suicidal thoughts, and then go and commit suicide and then say, oh, it's not our fault. There's nothing we can do about it. I mean,
Couldn't have seen that
what kind of
coming.
business practice is that, Your Honor?
Yeah, no, and I think that's really going to that res ipsa loquitur type argument that Ms. Jelkinen went out there and said was, well, you know, Judge, this is so obvious that it speaks for itself. This individual counsels with two, you know, licensed mental health professionals anyway. And then, you know, within days of those sessions, does make a suicide attempt, you know, regardless of, you know, whatever actions they took. Because, you know, I think there's an argument here that even if these two saw him and evaluated there being some suicide risk, their options are fairly limited. I mean, like a nurse, perhaps, they could report you know, his suicide risk and their evaluation of, you know, the degree of that risk. But ultimately, you know, other than making a recommendation perhaps for 24/7 supervision or, you know, that he get evaluated by a psychiatrist for a change of medication, you know, they're somewhat limited in their reactions, I guess. Isn't that true?
I mean, that could be true, Your Honor, but those steps that you just indicated or you just noted, Your Honor, those steps could have saved Benjamin Brown's life. It could have put him in 24/7 care and then sent him to a psychiatrist, and he could still be here today, Your Honor, and none of us would be here. I mean, those steps could have saved this man's life, and now we're gonna say, oh, they can't, they're limited. They could have took those steps that you just said, and those steps could have saved his life.
Well, I think you missed a key part of what I said there is they could have recommended that. I don't think either of them necessarily could have signed an order. You know, certainly it couldn't have admitted him to a hospital, which would have been that 24/7 care. And I'm not certain that either of these folks could have even ordered the Turning Leaf facility to heighten his level of supervision. You know, they could have recommended it based on the suicide risk, but I don't think, you know, that their qualifications or professional relationships with the facility would necessarily allow them to order them to do anything.
Well, I'd argue, Your Honor, that recommendation could have also saved his life. And just for them to throw their hands up and
Whether or
say,
not
well,
they recommended.
I'm still speaking, but
I'm
I can.
sorry. Excuse my apologies,
I'll
Counsel.
give you a chance to respond, Mr. Jucken.
Yeah, that recommendation could have saved Benjamin Brown's life. And so what the defense counsel is saying is that even though we have this, you know, this specialized foster care for people with mental health illnesses and suicidal thoughts, it's okay. Like, we don't care. They can just come and tell us they're going to commit suicide, and we're going to do nothing about it. And we're going to do absolutely nothing about it because we don't have to. Even though they can make these recommendations, they can go talk to someone, they can call, they can do all these things that they didn't do. And regardless of if they're required to, whatever, they had the chance to save this man's life and they didn't. And now they're saying, oh, well, we didn't have to, we're not qualified. Then why do you have why are you a mental health service provider? Why do you have this company? What is the reason if you're just going to let people come with suicidal thoughts and commit suicide? It's not like they were just like at a hospital. This is a specialized foster care for people with mental illnesses. It's not like they went to an ER and someone said, oh, I want to kill myself, I'm in so much pain. Okay, fine, maybe there's nothing that nurse could do. This is a specialized mental health facility for people with suicidal thoughts and mental illnesses. Are we just going to throw our hands in the air and say there's nothing we can do about it?
Well, and I do want to differentiate here. I mean, Turning Leaf is independent, and I'm not even addressing your action against Turning Leaf today. You know, and they may have different responsibilities, but that's just simply not before the court at this time. You know, what is before the court is, you know, these two Network 180 professionals who are independent. You know, certainly they should probably be aware that Mr. Brown's in this facility. They may have a professional relationship with the facility where they could communicate with his care providers there. But I'm not, you know, and I don't think you're asking me to find that they have any control over what happens necessarily at Turning Leaf. You know, they may have some input, but they're not the ones that call the shots regarding decision making by the Turning Leaf facility.
Well, I don't know. I think Turning Leaf might disagree, and Turning Leaf will say they just follow the recommendations of the Network 180 counselors. So I think that's a question between the two of them. I think Network 180 has a big say in the care for Benjamin Brown. And if Network 180 tells Turning Leaf this person is a suicide risk, we need to put him 24/7 care until we can get a psychiatrist to come and deal with him. Yeah, I think Turning Leaf would respond by saying, okay, we take your recommendation. And again, Your Honor, it goes back to this. If that took place, that could have saved Benjamin Brown's life. And now we're just going to say it doesn't matter. This is a mental health agency. This is what they do. And for them to just say, no, there's nothing we can do about it. Yeah, you make that recommendation. Turning Leaf they've said in their pleadings, Turning Leaf Network 180 makes a recommendation. they're gonna abide by it, especially with this guy with decades of suicidal thoughts. And he talked to 2 counselors 2 days and 3 days before the suicide saying, I have suicidal thoughts and I'm depressed. Of course, Attorney Leaf is going to say, oh yeah, this is a big deal. We should probably put this guy in 24/7 care and make sure he doesn't kill himself until we figure out what we can do next. Of course, Attorney Leaf is going to make that decision. If they don't, then shame on them. And that's why we're here today, Your Honor.
Well, that's why we'll be here eventually on the question of Turning Leaf's role in this whole thing. But right, I think the key question is, as you point out, there is some relationship here between these professionals and Turning Leaf. And so it sounds like you might be in disagreement with the idea that if I dismiss the malpractice claims here, I'm also dismissing what would be negligence and gross negligence claims against those defendants because you're saying, Judge, even if you agree that this, is not properly supported by an affidavit of merit as a malpractice claim, there certainly is a negligence claim here that they didn't act reasonably when confronted with the facts that they saw.
I think that is reasonable, Your Honor. I think they did not act reasonably at all when I'm not going to go into the facts again, Your Honor, but I don't think they acted reasonably at all.
All right. Well, let me return on all of those issues to Mr. Junkenin.
Judge, in your prior ruling, you said this case needed to be dismissed because they did not have an affidavit of meritorious claim. That was this court's prior ruling.
And the original complaint was exactly the same as the first amended complaint. It sounded in negligence, gross negligence, and malpractice.
Same thing. They just stuck a 3-page letter from Shiner on it and called it an amended complaint. But they realized the error of their way and now have an affidavit from Shiner. But that doesn't negate the central focus. Is Shiner qualified to testify against Kayla DeWeird and my other client in this matter? And absolutely not. He is not such an expert. And if you don't have that type of expert, the case law is clear. You have to dismiss the case. That's not to say they can't refile. And if it's so clear that to plaintiff's attorney that this was egregious malpractice, go get an expert that's proper and refile the case. But it can't proceed at this stage without the affidavit that you ordered they had to have.
And it can't proceed either as a negligence or gross negligence claim that these, what I'm going to call mid-level professionals, the qualified mental health provider and the counselor, perhaps based on their ability to make some recommendations or communicate with his residential facility at Turning Leaf, didn't act reasonably. I think you're saying, well, Judge, any way you cut it, the gravamen is still a malpractice claim with the standard of care there. It's just calling an apple an orange.
100%, Judge. You can cut, as the case says, a rose by any other name is still a rose. This is still a malpractice claim where plaintiff's attorney is calling into question the professional judgment of my 2 clients.
Yeah, no, I think I have to agree with that, in that the gravamen of the claims here, have been characterized in the complaint, the amended complaint, as both negligence and gross negligence. However, at the end of the day, the plaintiff's claim here does sound against Network 180 in malpractice, specifically in that it claims that 2 professionals at Network 180, I'll make sure I get their names right here. Miss Kayla DeWeird, who is a licensed professional counselor, and Amanda Irwin, who is described as a qualified mental health provider. I do know what a licensed professional counselor is. I'm less familiar with the qualified mental health provider credential, although I don't doubt that it is. another level of credentialing available to what I'm going to characterize as a mid-level professional working at Network 180, who is, Kent County's community mental health provider. They certainly have an important position in the world of mental health and treatment in the county. However, it still needs to be evaluated within the appropriate context. And in this case, these two professionals are being challenged on their judgment. Specifically, they both met with the plaintiff's decedent here, Benjamin Brown, before he attempted suicide. They did both note that there was suicide risk, albeit perhaps suicide risk that had been present for many years. And, in the light most favorable to the plaintiff in this case, perhaps, gave him the equivalent of, take an aspirin and talk to me in the morning and sent him back to where he was living at a Turning Leaf, a residential and adult foster care facility, as described by plaintiff in this case, for people suffering with various mental health issues, including presumably suicide risks. So, the alleged failing here is perhaps a failing of reporting or, recommending to Turning Leaf that a higher level of supervision, or perhaps, in another scenario, where the qualified mental health provider directs Mr. Brown, or perhaps even accompanies Mr. Brown into a hospital emergency room and has him evaluated in that setting for suicide risk, where at least a psychiatrist at some point could potentially have seen Mr. Brown, and if deemed acute enough a suicide risk, as he had been at some points in the past, he could have been admitted. And in fact, I think where the complaint here indicates that he was admitted, in May of 2023 for a period of time to Trinity Health because of suicidal ideation. Nonetheless, the Michigan statute is very clear on what is required in an affidavit of supporting a claim for medical malpractice, and specifically there. All right, statutory site here. It is a subsection, I believe it's 2169. Let me make sure I have that. I did make a note of it, and of course, then flipping through these different pages as I've been going through the argument here. Yeah, that is subsection 2169. Subsection 1A establishes a matching requirement, and that is as to a physician's recognized board specialty. There has to be what the Supreme Court in Stokes v. Swofford described as the proper fit. And plaintiff argues that the fit is here. And specifically what plaintiff says is psychiatry is the relevant overarching specialty because the duties here are, at the end of the day, psychiatric suicide risk identification, escalation, observation, and means restriction implemented by his team, which included the two professionals, Ms. DeWeerd and Amanda Irwin, employees of Network 180. However, I disagree that the fit is there because a psychiatrist, of course, has, as I stated earlier during the argument, many more options before him. And some of these are even cited here in Dr. Shiner's affidavit, in that some of the things that he cites in the affidavit certainly probably could be done by Mr. Weird and Ms. Irwin. That is obtaining a complete history including prior hospitalizations, medications, and treatments. However, one of the things that he cites as a deficiency here is a failure to diagnose and treat psychiatric conditions when indicated, prescribe or adjust appropriate medications with correct dosing. Well, that is simply not an option at all for these mid-level providers. They can recommend a consultation with a psychiatrist. However, neither of them, as far as the court's aware and as far as any evidence presented to the court, would indicate their ability to prescribe or adjust dosing, not even along the lines of a, physician's assistant or perhaps an RN sometimes can do, in a hospital setting, under the supervision of a physician, can at least make some medication adjustments. There is zero indication whatsoever that either of these professionals could do anything more than simply recommend a consultation with a psychiatrist. Now, that may have been what their duty was, but it's not the psychiatrist's place to say that the mid-level professional should have referred that person to me. That's exactly why we have the fit requirement, is because that would be the job of another person in the exact same specialty, and I'll note that defense counsel did provide affidavits of meritorious defense as to both of the psychiatric or counseling specialties cited here in the form of a affidavit from Miss Lisa Kalinsky, who is the equivalent of Kayla DeWard, a licensed professional counselor. And she says, of course, in her affidavit, that there wasn't any deficiency in the treatment here. And she is, as I said before, the exact match of qualifications to to the individual, Mr. Word. Likewise, there is an affidavit submitted of meritorious defense for Miss Irwin. That is by a Miss Kimberly Smith. Again, a qualified mental health professional and the equivalent of what Ms. Irwin's qualifications are, who says, countering the plaintiff's complaint that, to quote paragraph 11 of the affidavit, the care and recommendations by Amanda Irwin on July 6, 2023, Amanda Irwin and Network 180, her employer, were entirely appropriate given the mental/psychological situation presenting itself on the date of said treatment. And Dr. Shiner, on the other hand, finds fault, in addition to the things I mentioned previously before regarding prescribing medications, but also, finds fault in the failure to provide a safe environment for a suicidal patient and restrict or control access to means of self-harm. Well, again, these are perhaps recommendations that these professionals might have made. They might have made them to the Turning Leaf facility. Certainly that wouldn't be unheard of in the context of a residential facility to have a recommendation for increased supervision or perhaps decreased access to ropes, belts, things that might be used, somewhat similar to the jail, does when an individual is placed on a suicide watch. However, I do want to note, and this is an important factor here, is that, what Mr. Jelkinen says is true, in that, I guess, if we deemed it the proper course as a community, we could have every person who mentioned the very concept of a suicidal thought placed in a straitjacket and confined. But obviously, the medical community and the legal community have determined that would just simply be too much of a restriction placed, kind of hearkening back to the one flew under a cuckoo's nest days of, very heavy restriction of people suffering from mental illness, and that there's been a shift in society, and that we believe that people, even those that suffer from mental illness and suicidal thoughts occasionally, can't function in the community and should be allowed their maximum level of freedom and self-determination, even with their, very serious and life-threatening medical diagnosis. And of course, doing that does accept some risk of suicide with such patients. But, and someone in the position of Dr. Shiner, for example, if he were had admitting privileges at a hospital that he worked at, could, admit Mr. Brown to a psychiatric unit at the hospital, and perhaps even restrict his movement, his ability to leave that psychiatric unit until he was deemed not to be a danger to himself through suicide. But neither of these professionals, there's any indication, have that ability, ordering ability, or admission privileges, or for that matter, degree of control over the Turning Leaf facility in order to do anything more than communicate to them perhaps concern and make recommendations. And again, at this stage of proceedings, there's no indication that they didn't do that appropriately. And what Dr. Shiner's saying that they should have done are things that they could have not done. And that also, includes the idea of they certainly might have escalated the care here and, recommended and communicated the appropriate level of intervention. And that would include, like I said, emergency department evaluation or inpatient admission. But again, they couldn't order inpatient admission. The best they could do is say, Mr. Brown, I think you're at such risk. I'm going to walk with you over to the emergency room and have you evaluated there, and perhaps coordinate, what I'm going to describe as a warm handoff with the emergency room. But, until that point, as far as I can tell, Mr. Brown would have the ability to turn on his heel and say, I'm not doing that. Last time they put me in the hospital for a week, I don't want to go there again. And he would have the freedom to make that decision. There's no, level of control or order giving that a mid-level provider like these counselors can do, other than, and they're obviously, it's not, unlike I'm going to view as a top-level provider psychiatrist, they do have the ability to give orders, dictate medication changes. Of course, they generally, unless there's an order for treatment from the probate court, can't mandate taking medication. That still is up to the individual. Even the psychiatrist has significant limitations on what he can do with a patient that he's concerned about. But those are even amplified more in the case of counselors and mental health providers like Mr. Word and Ms. Irwin, who really also have to develop a two-way communication relationship with the patient. That, of course, facilitates their ability to gather information from the patient, build trust, and increase the degree of therapy that's provided to the patient, and that perhaps, their support and presence can mitigate suicide risk simply by the fact that they're giving voice and being a sounding board to that individual's concern. But they just simply don't have the power or the, and they're not held to those same standards as a psychiatrist for that reason either. And that brings me down to another, one of the findings of Dr. Shiner in the affidavit is, well, coordinate with and follow physician level psychiatric standards. And that essentially says it all. Neither of these folks are physicians, they're counselors. They're not held to those same psychiatric standards. It wouldn't be fair to hold them to that. And it wouldn't be proper in a medical sense either. Their role in the system is significantly different from what the psychiatrist is able to do. And likewise, the idea of ensuring staff competency and supervision regarding suicide risk assessment. Well, these are essentially staff members. Perhaps the psychiatrist or the management at Network 180 would be responsible for that, but there's no indication that they could do that or that they could direct the Turning Point facility, to have a higher qualified staff member supervise Mr. Brown or provide 24/7 eyes on care, etc. Those sort of things might be recommended. And I think that goes to the next point here where, he says, well, they could document and communicate risk status and safety measures so that necessary protections are in place and maintained. Well, they certainly could communicate that. However, they could, from anything before the court, they wouldn't have the power to make those orders. So the key here is that Dr. Shiner's affidavit, might be adequate to support a case of malpractice against a fellow psychiatrist because he does, even as plaintiff acknowledges on page, let's see here, it's in the response brief. I guess, unfortunately, not page numbered, but it does stay here in one of the paragraphs. Each item is a psychiatric standard. And that's exactly right. It is a standard for a psychiatrist triggered by a suicidal presentation, but not the proper standard to hold, these, what I'm going to describe again as mid-level or counseling level professionals too. It just simply is not the right fit and therefore not the proper affidavit. And I do agree that these claims, as I said at the outset, are properly characterized as professional malpractice claims, even if they are labeled in the complaint as gross negligence or negligence. At the end of the day, it is the professional decisions of these two individuals at Network 180 that's being challenged. And Dr. Shiner, though qualified perhaps as an expert and now with an affidavit that is in place properly, just simply is not the right fit. So in accordance with my June order, the case against Network 180 is dismissed at this time with prejudice based on that improper affidavit.
Yeah, can I say something really quick? I understand and I respect your decision, Your Honor, but we're focusing too much on 21691, which is about professionals, and we keep talking about Amanda and Kayla, Your Honor. They're not
Yes.
they're not defendants in this case. Network 180 is a defendant in this case. And Your Honor, with all due respect, you keep reading off Dr. Shiner's kind of list of things that Amanda and Kayla could have done. That we don't need to focus on that. Let's focus on number 7, the standard of care required by Network 180. That's a defendant in this case, Your Honor. They're duly accredited licensed healthcare institution and by through their agents, not limited to Kayla and Amanda, which hold themselves out to the public as being competent at rendering medical services, right? When they approach with someone like Benjamin Brown, what are they supposed to do? Select, employ, and train and monitor their agents to ensure that they're competent to perform these adequate medical care for a patient. Right? Ensure the appropriate policies and procedures are adopted and followed, including but not limited to protocol for identifying and handling a fall risk. I don't know why it says fall risk, Your Honor, but prevent the patient from suffering a worsening of their condition using all reasonable means. And Your Honor, and I'm going to go to Network 180's website, right? Because Dr. Shiner is saying they have a duty to train and employ employees who will do all this type of medical care that they're putting on their website. Adult crisis services are available 24/7. Am I in a crisis? A crisis is self-identified and is different for everyone. Number 1, do you have thoughts of harming yourself or others? Are you thinking about or planning to end your life? That's directly on their website. They have a duty to employ employees and agents who will take care of people who are suicidal. That's directly from their website. So forget about Kayla and Amanda, right? They're not defendants. Network 180 is a defendant. Dr. Shiner talked specifically about Network 180 and the standard of care that they have as a healthcare institution caring for people with suicidal thoughts. That is what they do. That is what they fail to do. Dr. Shiner is able to talk about that because 2169 is just about matching professionals. We don't need to match professionals here. Those two individuals are not defendants, Your Honor. Network 180 is the only defendant relevant to today's motion. And Dr. Shiner it can easily talk about suicidal thoughts and suicidal prevention when that is what Network 180 puts on their website. That's what they do, Your Honor. So I with all due respect, I think we need to reevaluate because we spent too much time on the 2169 with Amanda and Kayla.
No, well, I see what you're saying and I do appreciate it. However, I am, I think, right, yeah, clearly on paragraph 7 of Dr. Shiner's affidavit, he does cite, the standard of care for Network 180 by and through their agents, including but not limited to, and then he cites specifically Mr. Word and Ms. Irwin, and does find the same shortfalls in Network 180's relationship to this case, as he finds with those two individuals. However, there isn't evidence before the court right now, though I would, as I say, I will certainly take notice that Network 180 is our community mental health provider and does provide all of the roles that you stated on their website. That hasn't been pled adequately before the court, that they're in the shoes, at least, or should be held to the standard of a licensed psychiatrist. They might employ psychiatrists or contract with psychiatrists. I'm uncertain how they provide psychiatric care at Network 180. I know that they do refer to psychiatric care. However, I am not certain at all, on the basis of the complaint or the affidavit, that that's the appropriate standard of care to apply to Network 180 as an institution. So the only way that I can view their actions here are through the two identified employees, that being Mr. Word and Ms. Irwin. And as I stated earlier in the ruling, this affidavit is simply inadequate as to match their qualifications, nor is there sufficient information contained in the affidavit that Network 180 as an entity has to be held to, the standard of care testified to by Dr. Shiner. Now, again, you've got routes to appeal or question my decision, but I'm going to stick with it today, and that the affidavit as filed is just simply inadequate against Network 180, and specifically because it doesn't match the qualifications or standard that their two employees should be held to. And I think I've made a clear record of it. Certainly, you're welcome to appeal, or if you think there's some amendment that could cure, what I've identified, those routes are all open. But at this point, I'm going to stick with the ruling and dismiss the case.
Thank you, Judge. I'll submit an order to plaintiff's counsel for his approval.
Very good. Thank you, Mr. Jelkinen, and wishing you all a safe weekend. With that, we're concluding.